versus Semedo.
Good morning, Mr. Harwood.
Good morning, Your Honors. This is an appeal of a conviction for first-degree felony murder and armed robbery. There was an acquittal of a related charge by the jury of possession of a firearm. The case was tried on a joint venture theory before the jury, Judge Fishman presiding. And this morning I wanted to discuss three issues, the first being the sufficiency of the evidence. This is a case in which, and the Commonwealth concedes this in the brief, there was no identifying witness who observed the crime. The victim, George Fidalgo, was found shot and killed in his blue minivan outside Davies Supermarket, where he was an owner and proprietor. The only evidence that was presented with respect to Semedo was that 2 hours later in Brockton, he was in a brown van operated by the co-defendant, Danilo Lopes, and this brown van was identified by a witness, Antonio Fidalgo.
Mr. Harwood, could you step back to Boston for a second?
Sure.
Antonio Fidalgo said he saw two people in the van.
Yes.
Right, on Clarence Street. And one of them had dreadlocks and a Jamaican-type hat. Is that right?
No. He informed police that he saw a man in the van when he first walked by it, bringing in his child to the babysitter, who had a Jamaican-type hat on. He never indicated
He didn't say dreadlocks?
anything about dreadlocks. When Semedo was found by the police 2 hours later in a brown van, he didn't have a Jamaican hat on, and he did have long hair and dreadlocks. So when the Commonwealth indicates in its brief that Semedo matched the description given by Fidalgo to the police, that's not
So all you
true.
had was a darker skinned with a skinny face, is
Yes.
that right?
And a
Jamaican
Jamaican-type hat. And I think most importantly, when Fidalgo was shown both the van and its occupants 2 hours after the crime, Fidalgo did not identify Semedo as the person in the brown van, nor did he identify co-defendant Lopes for that matter. At trial, Antonio Fidalgo did not identify Semedo.
Well,
as
is
a
it
person.
fair to say that the evidence was sufficient to conclude that there were two people in the van? The van was involved in the robbery. One of them shot the victim here, and then they split the money. So the question simply is whether your client was in the van. Isn't that really the only question?
Well, I think Your Honor has certainly stated succinctly the best case scenario that the Commonwealth put forth. But at some point you get into...
Are you suggesting the van was not involved in the robbery, that this wasn't the money that came from the store that was found in the van?
There was evidence from which the jury could find that a brown van was at the scene shortly before. But there's no description of...
And then the money was found in the brown van in Brockton. I
Yes.
mean, the money that was stolen from the store. How can you say that that's not a reasonable inference? The brown van was seen at the scene just before it occurred. Two people in the van, apparently waiting for something. Man is shot right there. Money is stolen. I think it's an hour and a half later, but I'm not sure of the precise time. That van is stopped in Brockton. There are two people in it with the money.
Your Honor is correct. There is money in the van. It's true that the money has bands on it that one witness
Well, why don't we move
testified.
on to something that's really the nub of the case? I mean, whether,
I thought this was the number.
well, no, the nub of the case isn't whether it's this van. The nub of the case is whether there's enough evidence that this was the defendant in the van.
His presence at the scene. And here you don't have an identification by the only witness who even saw the two men in the brown van. You don't have any forensic evidence at the scene linking Semedo to the crime. The only evidence you have is you have money in a gray jacket that's in the van. money that I would say originally Sergeant Coleman said that the money was found in the same jacket as the wallet that contained Lopes's identification. At the trial, the testimony was the gray jacket contained money, and there was testimony that there was yet another article of clothing with Lopes's identification. But there was certainly no evidence, forensic or otherwise, linking Semedo to that gray jacket.
But there were 2 jackets in the van and 2 people in the van.
Yes. But no evidence linking Semedo to that jacket, forensic or identification of his in the jacket. So, and I would also note, I think the court's recent opinion in Zanetti, which I think is relevant here, there you had a lack of evidence as to joint venture deliberately premeditated murder by somebody in a car shooting and killing somebody in another car. And in that case, I think the court aptly observed there was after-crime evidence of a flight by the defendant, a destruction of evidence, etc. And in a footnote, Your Honor indicated that evidence is all well and good if you were proceeding as an accessory after the fact, but it says nothing about whether or not the defendant at the time of the crime or shortly before knew that the co-defendant or shooter was armed, shared an intent to deliberately shoot and kill the victim, etc. So here you have an incredible amount of inference would have to be drawn, and we suggest unreasonable inference, that Semedo was even present inside the brown van that was near the crime scene. Much less evidence that there was some kind of shared intent to kill somebody when there's no proof that he even knew.
I'm sorry, does it need to be shared intent to kill or just shared intent to commit an armed robbery with a gun or somebody?
I think that's a fair question. The Commonwealth in its brief said a shared intent to kill. And frankly, where it's felony murder, I don't know that that's exactly true.
And that was the only conviction, felony murder?
Felony murder, with armed robbery as the underlying predicate.
You just need the intent
So-
to commit
To
the
commit
robbery.
the armed robbery.
Right.
I believe that's correct. And I think the Commonwealth maybe overstated its burden with respect to that because, you know, it's a felony
Right.
murder. You have
Right.
to prove the intent to commit the armed robbery. And if the killing occurs in the course of the armed robbery, then culpability is attached. But here, my point is, you still, even with an armed robbery, would have to have shown not only the presence, which we say isn't proven, but also knowledge of a gun. And there's absolutely no evidence of knowledge of a gun. And at the end of the day, when you really look at this evidence, what evidence really was there that Semedo even knew Lopes? I would say
Well,
that this...
the evidence he knew Lopes was that he was in the van
car.
with him in Brockton.
Yeah.
Yes,
And
knew
unless he
that
was hitchhiking.
after
he
the
was-
fact.
Yeah.
Yes.
Right.
But
I mean,
but that is evidence that he knew Lopes.
I mean, I don't think it would be an unfair inference to figure out that if you were in the car with somebody an hour after a murder, that maybe you knew him before that hour happened. Don't you think? I
We're
mean, you don't
talking
even
about-
need to go
I guess
there.
my
You don't
point
even
is-
need to go there, though.
It's amazing how many inferences we're talking about. At some point, this Court's decisions in Ferguson and Mendili have to kick in and say, you can't support a conviction by inference upon inference upon inference, culminating in an inference that the person was not only present but knew about a gun, et cetera, et cetera. And I want to just segue into the juror letter that came the next day. A juror reported that they did have a reasonable doubt as to Semedo's guilt, and that this reasonable doubt was shared by a second juror.
But what do you do about our law that says we don't go into the mental workings of the jury?
Well, there are really two issues as to the jury deliberations. I just wanted to point out that this juror said that she did not believe that Semedo's presence was proven at the scene of the crime, and she even discussed...
But isn't that going into the mental workings of the jury? if we consider that at all. I mean, I understand your concern about the letter, but it seems to me that we've been pretty strong, we have strongly stated over and over that we don't go into the mental workings of the jury.
Before we even reach that second issue, Judge, the critical issue, I think, on the deliberations is that after 3 separate days of deliberations, the jury came in and reported that they were, quote, hopelessly deadlocked. And this was not after 9 hours of deliberation, it was after 13 hours of deliberation. And this was something that was reported. The defense counsels noted this, and then a second report came back of still being deadlocked, and that no amount of deliberations would change the minds of the 2 jurors.
And that's when the TUI charge was given? The second time, right?
After the second time.
But I mean...
And the defense counsel said, Your Honor, under the statute, you can't send this jury back out for another round of deliberations unless you advise them that they have to consent to further deliberations. The response of the court was, I'm giving a dynamite charge.
Right.
And there is reference in the record to him saying, I don't believe that the first time was due and deliberate. So Your Honors have to decide whether in a case which involved 4.5 days of testimony and approximately 13 hours of deliberations over 3 separate days, and the jury first notes saying, we are, quote, hopelessly deadlocked, which is something the appeals court has equated with due and thorough deliberation because that means there's been a back and forth, whether that was an appropriate ruling, that that's not due and deliberation. In a case where the judge himself said, this is not a particularly complex case.
But you know, it seems to me this is an area in which, and I think our cases support this view, that the trial judge has to have enormous discretion to make a judgment as to whether it was 9 hours, as I think the prosecution says, or 13, and I'll accept the 13, whether that really was due and deliberate. And I'm very hesitant to have appellate courts or to think that appellate courts should be second-guessing that. Obviously, there are extremes. I'm just saying, it seems to me there's got to be a broad scope given to trial judges to make those judgments as to when it is time to give the dynamite charge that then, triggers everything else.
Broad scope, yes. But I've looked at all these cases, and I haven't seen a case where you have 4.5 days of evidence, 13 hours of deliberations over 3 separate days, and a jury coming back and reporting we're hopelessly deadlocked. And then, as if to make matters even stronger for the defendant, to then have a jury note saying, hey, we couldn't take it anymore. That's what she says in her letter. These people kept pressuring us. They got angry, and we just couldn't take it anymore. Quote, I didn't have the strength of character to continue with this. And the question the court has to ask itself is, if Judge Fishman had properly said you have to consent to further deliberations, there's no way, given the showing from the juror, that she would have consented to further deliberations. But we don't have to show coercion. It's presumed under the statute. I'm simply saying on this record, it was clear, given its hours of deliberation, its report of a hopeless deadlock twice, that the statutory protection was triggered. And if not this case, what case?
I have a couple of questions, if I may. First of all, I assume you would concede that the Lopes case takes care of any of your argument on the motion to suppress. Am I correct?
As far as there's no difference between
Okay.
Lopes' suppression
Okay.
issue
All
and
right.
Semedo's.
And then my second question is, has the decision in Zanetti undermined your argument at pages 64 to 66, which I note are over the length of an ordinary brief, but this is where you argue that in the felony murder and armed robbery instructions, there was an erroneous charge on both principal and joint venture theories, even though there was no evidence to support the conviction of Semedo as a principal.
Not
Zanetti
only does
hasn't
it
changed
not
that at all?
undermine it, in fact, the decision directly supports it because, and I make this point in my reply brief, what the judge writing for the court aptly observed is the problem with a joint venture instruction as it's presently given is first you give the joint venture instruction as was done here, and then you define the crimes substantively. And when you define the crimes substantively as was done here, it sounds as if Semedo could have been a principal as well as a joint venturer. So here, even though the Commonwealth conceded and the judge found that there was no evidence of principal liability, the charge sounded as if you could find somebody like Semedo guilty as a principal because those substantive crimes were defined in such a manner that it sounded like principal. And I would point out again, here you have an acquittal on possession of a firearm. This goes back to the first argument. That charge was only submitted on a joint venture theory. So the jury must have found that there was no evidence even on a joint venture theory to support possession of a firearm, which is...
Not no evidence. I mean, there's all kinds of reasons why there might be slight inconsistencies in the verdict, as we know.
It doesn't augur well for the Commonwealth case where you're proceeding on a constructive possession theory of a firearm. The defendant is acquitted of that constructive possession theory. And knowledge is something that the Commonwealth had to prove in terms of its armed robbery and murder conviction.
I don't think you raised this, but of course we do 33E review here. Or maybe you raised it and I missed it, but I don't think so. Is there any Melendez-Diaz problem here with the medical examiner's testimony? Because I recall in reading the facts that a different ME testified than the one who did the report, but then I didn't see any argument on that issue. If
It
I'm
hasn't
right.
been argued. Of course, Your Honors can consider that
Well, that's why I'm asking you,
broadly.
is there an issue here of a Melendez-Diaz problem?
Not that we have resolved.
Certainly there was something that perhaps trial counsel hadn't raised an objection to.
I mean, did the testifying ME give any,
Did he testify only opinions?
only
or
to his own opinion, or did he testify as to the opinions of the examining ME who wasn't present?
I don't recall, Your Honor.
Okay.
But I
In
can
any event,
follow up with a letter
The
on
cause of
that
death
point.
was not a live issue at trial, right? I mean, it seems to me that how he died and anything that ME might have said really wasn't a very important issue for your defendant.
He did not present a defense along that line. Mr. Fidalgo was found dead in the blue minivan. But I will submit a letter as to that point that's been asked about.
If we can go back to due and deliberate deliberations, have you found any case in which we've said that a judge erred in this regard?
No. The closest case I found that has very helpful dicta and explains it is Jenkins. And in Jenkins, the reason that there was no requirement for reversal was because the jury was told that they had to consent to further deliberations by the court. So that's the case that I rely upon. And I rely upon an appeals court case which affirmed a conviction but said basically in dicta that, not a conviction, it was I think a civil case. They said that the deliberations had not reached a hopeless state.
Okay. And given Judge Botsford's concerns about the importance of a trial judge having discretion, what do you say the line should be beyond which a judge should not allow a jury to go back after a second declaration of being hung without giving them the opportunity to end their deliberations?
I would say, and it's difficult to say, this was not like a 3-month trial or something.
But it was
This
difficult
was a-
on the evidence. It wasn't complex, the judge was right, but it was a difficult case as to the evidence, whether there was sufficient evidence.
But you had 4.5 days of evidence.
But
And
it's a
13 hours
murder,
of
it's a life crime. Anybody knows that this is a very serious charge, and it's a question of the quantity of evidence. So even though it's not complex, you don't have a lot of scientific evidence to sort through or anything like that, you have a very weighty matter that could cause a lot of concern and deliberation.
On this record, 13 hours of deliberations, 3 separate days, a jury saying we're hopelessly deadlocked. If that's not due and deliberate, I don't know what is. It's just on this particular set of facts and circumstances, any reasonable view would suggest, I say, that that was due and thorough, and that there had been a back and forth. It hadn't produced a verdict, and you have the juror's letter after the fact to prove it. If there are no further questions, I would rest on my brief. Thank you.
Thank you, Mr. Howard. Good morning, Ms. Lee.
Good morning, Chief Justice. May I please the court? My name is Macy Lee, and I represent the Commonwealth. in
Could
this
you just
appeal.
help us with a factual issue? How many hours of deliberation had there been before the first note?
The deliberations began on Thursday, April 22nd, and it began precisely at 2:40 in the afternoon. The record does not indicate the exact time when the deliberations suspended on that Thursday, but I think for argument's sake, we can assume around 5 o'clock. So based on that, there are 2-hour deliberations there. The deliberations resumed the following day on Friday, April 23rd, and they began at 9 o'clock. The court did receive one note at that point that was marked for identification as S, and that note requested the definition of assault and battery. There's no other activity. Again, for argument's sake, I'm assuming the deliberations were suspended at the end of the workday at 5 o'clock.
With lunch.
So, I'm sorry? I mean,
With-
at 5
with-
o'clock, 5 o'clock. So
With
there's-
lunch, with lunch.
Yes, with lunch. So there's about approximately 7 hours of deliberation. So there is certainly, based on this, that the 9 hours of deliberation is probably not an accurate number, and probably 13, perhaps 13 is the more accurate amount of time that
Well, when was
lapsed.
the first note? When was it on
The
Monday?
first note, the one that requested the definition of assault and battery, there's...
No, I mean the first note suggesting they were deadlocked.
Hopelessly
happened.
deadlocked.
I'm sorry, that happened on Monday, on April 26th at approximately 11:30 in the morning. The Judge Fishman received the first note, which was marked as V for identification, and that note read, "Your Honor, on 2 of the 3 charges, the jury is hopelessly deadlocked. We have reached a unanimous decision on possession of firearm only." This note was then read in the record in the presence of counsel and the jury was present in the courtroom, and the judge then instructed the jury to return to the deliberation room and continue their deliberations.
Wait, so that makes 11 hours.
That's about approximately 11 hours, yes.
So, but you don't concede 13 then either, it's 11.
I think, again, because I'm not sure when the deliberation suspended, I think Judge Fishman, who presided over this trial, is probably the best judge to determine the amount of time that actually elapsed.
Okay.
And
Somewhere
he,
between
in his
11 and 13.
ruling, found that 9 hours occurred when the first note occurred, when he received the first
He
note.
said 9 hours?
He said 9 hours, yes, in his ruling.
Okay. Now, could you summarize for us the Commonwealth's best evidence that would establish that it was this defendant in the van in Boston?
Absolutely, Your Honor. I think what we have here is there are various pieces of puzzles, and when you put all the puzzles together, there's a full picture, and it can come to just one conclusion, which the jury can reasonably infer.
We don't need the editorial.
Okay, well, no, but I think we do have pieces and pieces of evidence here, and I think that if you view the timeline of the case, which began at 7:30 in the morning, and if I can go back even the day before, Lopes had asked his friend, Luis Goncalves, to borrow the van, and that was on April 22nd. He gained possession of the van at approximately 7:30 in the morning on April 23rd.
How does that help establish it's this defendant in the van?
Again, like I said, that's just
Okay.
one little piece of the puzzle, and that puzzle alone, that piece alone establishes nothing. Truly,
Right,
it does
so
not.
I'm asking you to give your best summary.
And I think, again, my best summary is it includes the entire timeline. The court must look at the entire timeline to reach the conclusion. So Lopes has possession of the van. Davies Market is open at 8 o'clock in the morning by the victim and his wife. At approximately 9 o'clock, Antonio Fidalgo, the victim's cousin, went to the store, spoke to the victim. He then drops off his older son. He then comes back to the area. He parks his car in front of 45 Clarence Street. And I'm assuming here the time was probably about 9:15, 9:30. He then notices a dark-colored...
I mean, it has to be a little longer, doesn't it? He came at
Perhaps.
9.
He said that he was at the store, the market, at 9 o'clock, and then he had to return home to get money because he had forgotten money to pay the sitter, and then he went home, retrieved the money, and then dropped off his older son at school.
In
So-
10 to 15 minutes?
Yeah, I don't know. I don't know. There's no testimony to that effect. But again, the officer, Sergeant Detective Gallagher, arrived at the scene at 9:50, so it was somewhere between that period. But when Antonio Fidalgo then dropped off his second and third son at 47 Clarence Street, that's when he noticed the brown van that was parked behind his minivan. He noticed that it was a large passenger van. He was unable to see the face of the driver because it was dark inside the van, but he did know that the driver was wearing a Jamaican-style hat, and this is his testimony, that was typically worn with someone who had dreadlocks. He noticed that the driver had a dark complexion, and a skinny face. He also noticed that there was a second person in the van, but in the rear of the van, making movements. He wasn't able to make out the face, but he did see the shape of a body and a head. He drops off his third son at 47 Clarence Street. He spends approximately 15 minutes inside. When he returns... 15 minutes. When he returns, he notices that the van is no longer there. But in place, between 47 and 45 Clarence Street, is a light blue minivan with the engine. He did not testify that the engine was running. That was Sergeant Detective Gallagher. But he did notice that it was in the middle of the street. The driver was slumped over towards the middle of the van, and his hand was on the floor. He thought that the person had a heart attack. He then returned to the sitter. Sitter realized immediately that it was the victim, and called 911. Sergeant Detective Gallagher then arrives at a scene at 9:50.
Okay, so now,
Yeah, how
an
does
hour
this
later,
help
we get to
establish-
Brockton.
We're going to get to Brockton right now. At 10 o'clock, Eusebio Oliveira, who is a manager of a junkyard in Brockton, testifies that he started his job at about 10 o'clock. Sometime after 10 o'clock, the defendant came into the junkyard. He recognized the defendant immediately because the defendant had appeared at the junkyard 6 to 10 times. He's had about 10-minute conversations with him each time, and each and every time he wore a Jamaican-style hat. He had dreadlocks. This time he was with another gentleman, a lighter-skinned person. They both then went to the soda machine, which dispenses Minute Maid orange soda, and that becomes relevant because the bottles are found in the van later on, which indicates that the van was at the junkyard. They both,
At 10 o'clock.
sometime after 10 o'clock. Again, unfortunately, I can't give you a precise time, but Oliveira did testify that it was sometime after 10 o'clock when he began his shift.
Did
at the
Oliveira
junkyard.
say whether the defendant was wearing a Jamaican hat
He was.
this time?
And on April 23rd, that day, as all the other times when he appeared at the junkyard, he had on Jamaican-style hat. I believe it's red, orange, and green colored Jamaican-style hat. He had dreadlocks. He had a dark-colored jacket on. He did not see him leave the junkyard. At 11 o'clock on Warren Avenue, the junkyard's on Thatcher Street. On Warren Avenue, Officer Robert Smith stops the van. The van, as the court well knows, based on a decision in Lopes, that it was a dark-colored van, and the defendant is in the car, in the passenger seat. He does not have the hat on, but he does have dreadlocks. Antonio Fidalgo arrives at the scene. He's unable to identify, yes, the defendant, because he, quote, was not 100% sure. But he positively identifies the van as the same one that was parked behind his minivan in front of 47 Clarence Street. So taking all these factors together, there is an established and overwhelming conclusion that the defendant's presence was at the murder scene.
I don't know that it's overwhelming.
Well,
Aren't there some other facts here, too? I mean,
there are other facts. A subsequent search of the van revealed...
It's a positive ID of the van, or wasn't it? Looks like it, or...
There's definitely testimony from Antonio Fidalgo that after the police arrived at the scene, they drove around the area looking for vans. He thought he saw one that possibly resembled the van that he had seen, but when he arrived at Brockton, he positively identified that particular
Had
van.
he seen the Cape Verdean flag in the van when it was parked on Clarence Street?
Yes, he did, and he noted that it also had tinted windows as well. Yes.
So we've got a similar color, tinted windows, flag, same size.
Yes, he said it was a passenger-sized van. Another thing that's noted that's part of this puzzle is that in the van, subsequently when it was searched, there were two jackets inside. There was a denim jacket which contained Lopes' identification that also did not belong to the owner of the van. There was a gray velour jacket that also did not belong to the owner of the van, and I think an inference can
Dark
be made.
gray, light gray? What kind
I
of
think
gray?
there was no testimony. It said it was a gray velour
Is
jacket.
it any evidence?
Yes,
We'll see it.
yes. There's no light.
Because you said that the
Dark.
owner
Right.
of the Oliveira said that
Yes.
it was a dark jacket.
He did say it was a dark jacket, but again, there's in this case, in Lopes, there was questions about the color of the van, and I think here I don't know if it's dark or light, but it was a gray velour jacket that was found, and inside the pocket of this jacket was $2,006 in various denominations and bound together by paper counting bands. Those paper counting bands were also found in the victim's car. These counting vans were also provided to the police by the victim's wife. And
Is there some way that it's perfectly clear that it's the same set of counting vans?
and I believe in the record there is no direct testimony to that. I believe the photographs reveal, and there's no testimony to support it, that accompanied the photographs. But again, the photographs reveal that these counting vans were.
Anything that ties that jacket to the defendant?
Nothing directly, but again, reasonable and plausible inferences can be made that the jacket did not belong to Luis Goncalves, the owner of the van. It did not belong to Lopes because Lopes' wallet with his identification was in the denim vest. So there's only one other person in the van, and that is Semedo.
Well, that's in the van at that time.
Yes.
Okay, but it also could be money that was split up afterwards, although.
Absolutely, it could be. And again, but it's also important to know that 2 days later, after the murder and the crimes, Lopes turned himself in at the Brockton Police Department, and he turned in, when he turned himself in, $2,175.
How does that come into evidence at the trial of Semedo?
That comes in through the testimony of I believe it was Sergeant Detective Duggan, who testified to that effect. And there is no other testimony other than that. Lopes appeared at Brockton Police Department. He turned in $2,175, and later that day, a search warrant was executed on Otis Street in Brockton, where the murder weapon was found under a dog.
So the murder weapon came in here as
It did
well?
come in, yes, and the ballistics match the
So
warrant.
how did I mean? Explain the testimony a little bit. How did that happen? We went to this doghouse and found a gun.
There was essentially it was what I just said. That after Lopes appeared at the Brockton Police Department, they obtained and executed a search warrant at Otis Street, and the firearm was found under a doghouse, and I believe it was in a pink bag, and that was the extent
So
of the testimony.
what inference is the jury to draw from that?
That there is a connection to Brockton because they were in Brockton at the junkyard and stopped at Brockton. Otis Street was located in Brockton, which is where the gun is. That the inference can be made that somehow between this time frame, the murder weapon was dropped off at Otis Street, and that both did it, and that both Lopes and Semedo were together when that occurred.
So, Ms. Lee, I understand the Brockton piece, but how do we link that back to the Boston police? Is it only time?
I believe it's yes. It's the time. It's the van that was in.
No, I understand that. I understand that once he's in Brockton, you're in the van and you've got the junkyard owner, but it's what's the evidence? I mean, I'm keeping your timeline, and until you get around to Brockton, there's not a lot there.
I'm sorry?
There's not a lot there.
No, there isn't. But again, you have someone who's wearing a Jamaican-style hat.
No, I understand that. I mean, so you might have an accessory after the fact. You could have all kinds of things, but you're looking for murder one.
Right. And and there definitely can be scenarios. But again, the jury is allowed to conclude and draw reasonable and plausible inferences. And based on all these numerous factors, including what was found in the van, the victim's van, the timeline, the travel, that both of them were seen together at the junkyard and
But
afterwards.
that's afterwards.
Could I ask you a question? I'm sorry, just about what you just said, that I understand that it came in that the search warrant, gun is found under the doghouse, but I think you said they both were in the van there. Is there any evidence?
No, there's no evidence. And if I did say that, I apologize. No, there's no evidence to that at all. But again, what I'm arguing is that that's a reasonable and plausible inference because of the location. It's in Brockton, and they were in Brockton in two different locations.
So how is the jury to infer that the defendant had knowledge that the other person had this gun and intended to use it in the robbery?
I think it can be inferred that he was lying in wait while he was parked on Clarence Street. There are 2 pairs of white gloves that were subsequently recovered in the van. One of them happened to be in Lopes' jacket.
White gloves are interesting, but what do they mean exactly?
I think the inference can be made that they were used. There were 2 pairs, so there's one for each person, Semedo and Lopes, and that they were used to execute the crime. They did not belong to Luis Goncalves, the owner of the van, so they could only belong to 2 other people who were using the van at the time.
So if you can put Mr. Semedo in the van, the fact that they were lying in wait,
Right.
that one of them had a gun, and that they had white gloves, which I guess suggests they didn't want to leave fingerprints.
Yes.
I'm not sure how that has to do with
Was
an
there
armed
any
robbery,
evidence about what the white gloves were used for or could have been used for?
No, just that
I mean,
they...
you think that's common knowledge?
I think that an inference can be made by the jury. And again, that the fact that the victim's car was stopped right in the middle of Clarence Street, the engine was still running. that an inference can be made that Semedo, who was sitting in the driver's seat, pulled out when he saw the victim, because there was testimony that his customary spot was taken that morning and he had to park on Clarence Street. That Semedo perhaps pulled out and stopped the car because he was in the driver's seat, and that he drove the car to Brockton.
Now, there's another piece of evidence that I haven't read the transcript, so I don't know how it fits in, but there's a Nissan found
Yes.
somewhere in the area of the robbery. Was that connected to the defendant?
There's no testimony connected to the defendant. That Nissan, I think, was found a block away. It was around, because Dudley Street's here, Clarence, was around, I think it's around the corner,
So what was it admitted? What was it admitted in evidence for?
It was simply the testimony that when they had closed off the area as a crime scene, they located this white Nissan, and there was no other testimony to that effect.
So why was it introduced?
I don't.
There was no testimony linking it to a relative of the defendant or anything?
It was.
There's sidebar conversations related to it, which
okay.
I know about.
Wasn't it? Yeah.
But there was.
I remember this at the Lopes trial, but
There
I
was
don't
no.
know
There
what
was no testimony. I think the testimonies began, and then there was an objection. There was sidebar,
Okay.
and of course I know the
Well, we'll
information.
look at that, sure.
But there's nothing linking to it. But eventually, this car somehow links Semedo down Connecticut.
Okay.
So
I was just going to move to the next
Yes.
point, and that is don't you think in this case, after somewhere between 9 and 13 hours of deliberations over 3 days, that it was an abuse of discretion for the judge to conclude that they really hadn't deliberated thoroughly?
Absolutely
in the first
not.
note case?
Absolutely not, Your Honor. Again, bringing back to when the deliberations started, it started at 3 o'clock. So there's 2 hours there. And then you had a full day the following day at 8 o'clock, and then the weekend. And then when they started on Monday, it was in the morning at 11:30. And given the nature of this case,
Well, it certainly was a difficult case in the sense of being a close case.
right.
But isn't it troubling? I mean, counsel points out that you've got this letter saying we were locked in this room and we were sort of verbally abused, and we kept being sent back and were verbally abused some more. I mean, isn't that exactly what 234, Section 34 is designed
No,
to
it's
protect
absolutely
against?
not. In fact, Section 34 it's not designed, it's not designed to delve into the working and thinking process of a jury.
No, but it's
no,
designed
no,
to
it's-
keep the
but-
pressure,
Right.
to keep undue pressure off jurors to reach a decision when
Right.
they honestly disagree.
Right. But here you have, the court estimates 11, 13 hours. I'll argue 13 hours just for argument's
Okay,
sake.
sure.
We have 13 hours here. That is very minimal compared to the nature of this case. Although it's only 4.5 days of testimony, it's still a murder case. And
13 hours is, I mean, after 4.5 days of trial?
no, it's not, because again, given the breaks that they had between the weekend and the nature of the case, although the evidence was not complex, but given the fact that, again, many pieces of puzzles here that must be considered jointly and even independently, it is not, there was no abuse of discretion. And the trial judge does have broad discretion.
Why didn't he agree to, why didn't he, select the jury, that they had to consent to go on again?
Because again, he properly determined that the first note declaring deadlock, which is note V, did not indicate due and thorough deliberations.
Okay, but the jury apparently in that first note said we've already reached a verdict as to one of the counts.
Right.
So if they've reached a verdict as to one of the counts in a difficult case, how can you say they haven't duly and thoroughly deliberated?
Because again, we don't know what that count was. It
Yes, we
could-
do.
Well, it was possession, you're right. It was
Possession of a gun,
It was
which
possession.
is
Which
part
the-
of, an important part of.
Right.
So they clearly had come to a view of that.
Right.
And that is to be part of the deliberations with regard to the felony murder. So how can you say that they've not duly and thoroughly deliberated when they've already reached a verdict as to one difficult count?
Because I think, again, viewing the entire timeline of the jury notes, this was the first note declaring deadlock. There were no other notes before that indicating there was any other troubles. In fact, the note before that was the definition for assault and battery. So again, Judge Fishman, who presided over this trial, has a very broad discretion to realize that, look, this has been 13 hours, even though he determined that it was 9, that the jury did not reach due and deliberations, due and thorough deliberations.
Ms. Lee, Mr. Harwood relies on Jenkins, and you didn't respond to Jenkins. Your view?
Jenkins, I do not know the case on top of my head, but I
Okay.
can follow up on 16L letter. I read it quite some time.
I mean, there, you know, there was you got a consent to continue, but
Right. But again, the trial judge does have the very broad discretion in making that determination, and here there was no abuse of discretion, given the time, given the nature of the case, the charges.
I guess the concern is that if we give judges unlimited discretion, then the statutory language is essentially ignored. So there has to be some limit beyond which you can't do it. Where do you say that limit would be?
I don't know, and again, I think it's a case-by-case basis. Certainly in this particular case, there's no risk whatsoever of an abuse of discretion, given the time and the nature of the case. Perhaps if it's a district court case and they deliberate for 5 days.
No. I mean, a district court case, just as serious. I mean, I know
It is, but
homicide.
I'm just saying that given
I know
5
homicide
days,
is complicated and it's the most serious thing,
Right.
but they're very serious crimes that take place in the district court. So you said, you know, where's the limit? Don't know. You know, case by case. That's no answer.
It is, and I think that's the reason why the statute allows for a trial judge discretion, because I think it's very difficult to say, for all of us to say, which case wherein a jury would reach a level of due and thorough deliberations, because every case is individual, every case has its own evidence and its levels of serious, some obviously more serious than others. In this case, where you're facing the highest degree of murder, which is first-degree murder with a potential life sentence, that is a serious case, and 13 hours is not at a point of due and thorough deliberations, as properly found by the trial
But again,
judge.
the issue is
Yeah,
not
of
whether
course.
he declares a mistrial.
Right.
The issue is simply
Whether
whether that
it
counts as
triggered.
one of the two.
Right. And here he did, and again, the second note, he determined, the proper determination, that Section 34 was implicated at that point.
Ms. Lee?
Yes.
I see your time's up. Your brief was very helpful, but your brief was over the length of pages, and do you really think that we need 3+ pages on the law of what evidence is sufficient to warrant a conviction? Wouldn't maybe one sentence or
Perhaps
one
not.
citation
I will
But I mean, over and over this happens, and it makes the
Right.
brief be 70 pages where it really doesn't need to
The
be
next time I
over
file a brief,
50.
I will make note of that, and I will cite to you.
Okay.
But I always do, because just
But
as
you
a
can
safeguard,
evidence
so.
by these questions, we are
Right.
aware of
But I
the
thank you for reading
standard.
it, though. So.
But there are obviously counsel in this room who appear frequently. We're trying very hard not to make mandatory things, but these briefs, we don't need it. We really, I mean, especially murder one cases, we do 33E reviews, and a lot of the law is settled. It's much more helpful if you say, this is my key case, this is helpful to me, and especially on stuff like Lattimore and so on. So, fair warning.
I will note that. Thank you, Your Honor.
Thank you.